have the pleasure of also introducing our next speaker, Eric Goldman, who is the Associate Dean of Research, Professor of Law, and the co-director of the High Tech Law Institute. I'm guessing many of you know him by his blog, Technology and Marketing Law blog, which covers a range of different issues related to the internet. He's here to talk about his co-authored book with Jeff Kosseff on a retrospective of Zeran versus America Online. With that, I will turn it over to Professor Goldman.
Thank you, Professor Lee. And like Professor Sandine, I want to say thanks to you for organizing this book talk series. It's a great service to our community to have these kinds of conversations. And so thank you for doing the work and for helping convene this conversation. And of course, I want to extend my congratulations to Professor Sandine and to her co-author, Professor Levine, for the work they're doing in the information law book. And their work evangelizing that as a new way of thinking about a bunch of disparate issues that many of us run into on a daily basis. So it's a great honor to be able to follow her and the work that she's doing. I'm going to talk about the book, and let me share my screen here, called Zeran versus AOL. And this is a book that we released at the end of last year. I'm sorry, Professor Lee, can you see my slide?
Yes, but it's not yet in the present. Yeah,
okay, terrific. And this book covers a specific legal case, Zeran versus AOL, which came out from the Fourth Circuit in 1997. But it's really a great case study of a lot of different things. It's a case study of litigation in the internet context and more generally. And we have some materials to help people think about it as a case study. And it's also a case that's cast an enormously long shadow on internet law. And so it's a chance for us to really step back and say, what do we know then? What do we know now? What's the difference? And what does that teach us? So I'll talk about the book later, but I have to talk about the case first. And I do this in part to educate the people who may not be familiar with the story in addition to the lawsuit. And it's a classic story. It's one of the classic stories of the 1990s internet. And in particular, online, I was chatting with some folks about this talk, and I analogized it to telling the story of Passover. It's a story that benefits from retelling to each new generation. So for those of you familiar with this case, I probably have some details to add. But if you're not familiar with this case, look at this as a really great opportunity to learn about what we were doing back in the 1990s and how we've grown since then or not. As Professor Lee mentioned, I put this book together with a professor at the U.S. Naval Academy, Jeff Kosseff. This book is freely available as a PDF and as an ebook. You're free to download it anywhere. We're not charging for it. And in fact, he's not allowed to make money without going through a bunch of hoops because of his status working for the U.S. Navy. So we don't have any place where it's commercialized at all. Go ahead and enjoy it as you see fit. So just to start with the top line perspective, why do we have a book about this particular case? What makes this case worthy of that? There's a few things that stand out about the case. First, it was the first appellate ruling on Section 230. And we'll talk a little bit more detail about what Section 230 says later. But the short story is that Section 230 says that websites aren't liable for third-party content. But part of why I'm able to say that so confidently is because this is the case that told us that's what Section 230 statutory language might mean. And it was the first appellate court to do so. By doing so first, it basically primed all the cases that came after it to either fall in line with it or to challenge it. And some cases have challenged it over the years, but the reality is that most courts fell in line like we would expect in a common law tradition. The first precedent then became quite persuasive. Not only that, the court took a reading that we could debate whether or not it was strictly required by the language of the statute, but the court applied a broad reading of Section 230. It took the various statutory words and gave them an expansive interpretation. And it did so embracing the common norm at the time in the mid-1990s of internet exceptionalism, that the internet was unique, special, and different, that it should be legally regulated in a unique, special, and different way, and that we would get unique, special, and different benefits from the internet by doing so. So there might still be a norm about exceptionalism for the internet today, but it's certainly not favorable like it was in the 1990s. The view today might be, yes, the internet is unique, special, different. It makes everything worse. But that wasn't the norm in the 1990s. And this opinion is really a dramatic example of what the conversation was like in the 1990s, thinking we got to protect the internet. We got to make sure that we can see it mature to its full potential. Something that other courts might not have done, but this opinion did. And the third reason why this opinion is that the combination of the Section 230 statutory text plus a Zeran ruling has become the foundation for our modern internet. Basically, if you look at what we do online, it's all involving user-generated content. That's the dominant usage of the internet. And the reason why we can have such widespread proliferation of user-generated content services is the combination of Section 230 plus the way the Zeran court read it. Now, I say for better or for worse. I think that there's a lot of things we got because of the combination of Section 230 and Zeran that have made our lives demonstrably better. And the fact we use user-generated content services so frequently is a sign of how important it's become to us. But all the things that people are concerned about the internet or reasons why they hate the internet could also trace itself back to the Zeran ruling as interpreting Section 230. So this opinion is one of those watershed opinions that really represented possibly a fork in the road of how we might have seen the internet develop. A different opinion reaching a different conclusion, or a different opinion worded differently, might have led to a dramatically different internet, for better or for worse. But it gave us the internet that we have today, for better and for worse. So what I'm going to do is I'm going to talk about the case. And again, I'm assuming that many of you did not actually live through this time period. If you did, some of this will be familiar. But for those of you who didn't live through it, let me tell you why this case got such attention. And let's start with just who Ken Zeran is. This is the plaintiff in the case. Ken Zeran, this is from his website when it was still functional, how he self-described himself. But let me give you some of my characterizations of him. Zeran is based in Seattle. He also says here he's been based in New York City, but at the time he was based in Seattle. And he's an artist. It's almost like a polymath. He does a lot of different things. And if you read his bio, you'll see he's had some really rich, fascinating life experiences. But in this circumstance, we really care about his role as an entrepreneur. So at the time, he was trying to launch a classified ads business, where he was basically going to create a publication that contained listings for various rental properties. Today, of course, we say, well, why didn't he just put that on Craigslist? Or why didn't he put that onto one of the online marketplaces? But at the time, there was still much more interest in print than electronic. So he was trying to create this print publication. And it's unclear how it ended up that he was living at home, but he was living at home at the time. So he was literally running this business out of his parents' home. And not only that, he had the same phone number for his home and business. Now, today, that might not sound radical because we have our cell phone, and our cell phone is usually used for both business and personal purposes. But at the time, it was pretty common that people would have two different phone lines, one for their personal life and the other for a business. But in his case, it was actually the same number. And you're going to see that proves to be crucial because of what happens to that phone number. Okay, so this is Ken Zeran, the plaintiff, this interesting guy with an interesting story, trying to launch a new business. And then the flashpoint for this case is the Oklahoma City bombing, which for those of you who are Gen Z, you don't even remember this. This occurred before your time. And certainly it's been washed away in part by subsequent events. But on April 19th, 1995, so just a little bit over 26 years ago, two gentlemen, Timothy McVeigh and Terry Nichols, worked together to blow up a federal building, the Murrah Federal Building in Oklahoma City. What they did is that they made a bomb out of fertilizer. They put it into a rental truck. They drove it to the front of the building, and then they blew it up. You can see on the right there what happened to that federal building. You can see basically the bomb virtually ripped the facade off of that building. And you can see at the bottom here, the gentleman on the left is Timothy McVeigh. The person on the right is Terry Nichols. So the consequences of this bombing were horrifying. So 168 people died in the bombing. That included 19 children. At the base of that federal building was a daycare center where children were in the daycare's care. And you can see how the building just basically collapsed on the daycare. 680 people were injured. The damage and property value was $650 million. This was a major terrorist attack. And indeed, at the time in 1995, this was the deadliest terrorist attack on U.S. soil. So obviously today, when we think about terrorist attacks, we think about things like the 2001 attack on the World Trade Center and on the Pentagon and elsewhere. We think about the 9/11 attacks as being the worst, and certainly they were far more deadly than this. But if you can try to imagine what life was like pre 9/11, to have two Americans turn on our country to weaponize ordinary fertilizer, turn it into a bomb that was so destructive and so murderous, it really shocked the American conscience. And certainly, as you can appreciate, in Oklahoma City, this was a major disruption to the social fabric of that community. Everyone knew somebody who was affected by this bombing. So that'll become important as we see about how powerful this was in Oklahoma City. So it's hard to, again, imagine what this was like, but just imagine, at the time, someone coming and saying, this is the most deadly attack that we've had on American soil and being conducted by our own Americans. Really, really shocking to the American people. So remember, that was April 19th, 1995. And then what happened is a series of attacks on the America Online service shortly thereafter against Zeran. So for those of you who aren't familiar with it, though I think most of you are, America Online was what we called a commercial online service back in the 1990s, and it was the leading one at the time. It was what we might call a portal. So it meant that you would go to America Online and you could do pretty much everything there. They had email or private messaging services. They had instant messaging services. They had message boards. They had proprietary sources that you could read. And at the time, they had launched the ability to then use their servers to connect to the rest of the internet. So you could actually get to the rest of the internet using AOL as an internet access service. So we're going to focus on the message board functionality that was proprietary to AOL. So there were these message boards that were only available to AOL subscribers, and they were quite active at the time. People liked talking to each other in that format. So there's an active conversation that's taking place. So in one of those message board forums, on April 25th, 1995, so this is now 6 days after the bombing, a user who went by the username or alias Ken ZZ03 posts messages about naughty Oklahoma t-shirts on one of AOL's message boards. I'm going to show you what that looks like in a moment. But let me walk you through the timeline, and then we'll take a look at just why these were so outrageous. And I apologize, I'm getting an incoming call. Let me see if I can get rid of it. You sometimes will hear the expression too soon. This was a good example of too soon. As you can imagine, emotions were extremely raw, not only across the country, but certainly in Oklahoma City for someone who's posting about this terrorist attack. This is now followed up by a series of additional messages. On April 26th, the next day, Ken ZZ033 posts a message. So notice now you've got somebody who is shifting their identity, creating a different account. So even if AOL had properly addressed Ken ZZ03, it wouldn't have stopped Ken ZZ033 from posting a message. I'll show you that message as well. It's even more offensive. And then from from April 26th through May 1, Ken Z033, so a third different alias, posts more messages, again, also offensive. And so this problem is festering until May 1, when two radio disc jockeys at the Oklahoma radio station KRXO are informed about these messages being posted on AOL. And they weren't able to confirm whether or not they were legitimate, but they went ahead anyway. They went onto the radio and said, there's this joker named Ken who is posting these messages that are offending our community. So why don't you call Ken and give him a piece of your mind? So you can imagine taking this already combustible situation, this radio station just dumps gasoline onto it. In the place where Oklahoma City, where people are still reeling from this tragedy, the radio station says, someone's making fun of us. What do you think about that? You can imagine the response from the Oklahoma City community after the radio station did that. So we'll talk about the response in just a moment, but meanwhile, Ken Zeran is contacting AOL and saying, what's going on, guys? Can you help me here? And on May 4th, AOL says, we don't have any records about who these people are. We've already purged all of our server logs, so we cannot tell you who created these accounts. And that's actually the basis of Zeran's claim against AOL in the end. He sues them for negligence, saying, you shouldn't have wiped that information. I needed that information in order to be able to sue the bad actor, and I can't get it. You no longer have it. I will add that things started calming down starting after May 7th. The Oklahoma newspaper, the Daily Oklahoman, runs an article about how Ken is getting pranked. And I'm going to show you that article in just a moment. Okay, so you can see the timeline that, from April 19th, the bombing, to April 25th, the first attempt to attack him, to the magnification of that on May 1st. You can see how quickly things were spiraling out of control for Ken Zeran's life. So in his complaint, he alleged some of the following harms. He alleged that he was getting 2 angry calls a minute through the end of April. So just think about that. Every 30 seconds, he's getting an angry call saying, you're a terrible person for doing this. In some cases, threatening him with death. He's still getting calls even after the newspaper article, even after the radio station said, hey, guys, we screwed up. He's still getting 15 calls a day, basically 1 an hour, every waking hour through the end of May. So he has just gotten a tsunami of angry phone calls, threatening phone calls, and scary phone calls. Because all of this came in through his personal/business line, he's out of business. He cannot run his business because he can no longer take incoming calls from his legitimate customers, and his line is constantly tied up. Anyway, he can't run his business using his phone number. And finally, he was so scared by the tenor of the calls that he calls up the police, and they actually give him police surveillance. So they come in and actually protect him from some of the alleged death threats. So I think we would say that this is really a pernicious set of harms that have been imparted onto Ken Zeran, that someone attacked him in a really powerful way that dramatically diminished the quality of his life for weeks on end. Okay, let me show you some of the examples. This is the April 25th post, and you can see the subject line, Naughty Oklahoma T-shirts. Says 6th grade Oklahoma T-shirts order used today, and then they've got the slogans. So slogans like McVeigh for president 1996. You can just imagine how offensive that's to many people. Timothy McVeigh is the worst domestic terrorist and someone saying, let's elect him. But things like putting the kids to bed, Oklahoma 1995, not only are we upset about the loss of life generally, but the idea that these innocent children in the daycare are murdered really is just going to rub people raw. And then notice down below, it says things like, here's the price tag, here's the nature of the shirts, here's the options. We will we'll get it out to you fast. So this wasn't just a joke in the most in kind of the rough sense. Somebody went to some care to try and provide enough details to make it look like this was a credible message, like someone was actually really trying to run a business. So you can, at the bottom, you can say, please call, and there's the phone number that Ken was using. Indeed, my understanding is, at least until a couple of years ago, he was still using that phone number, even today. Not sure about the most recent days, however. And it says, ask for Ken. Okay. Here's the Ken ZZ033. You've got the same t-shirts in the first bucket, and it says, I've got some new items here, and then some really horrible statements here. And now it goes on to say, I'm donating $1 from every shirt to the victim. So again, establishing the implicit credibility, like this is actually someone who's trying to commercialize this tragedy, and they're, as a gesture of trying to show that they understand the nature of tragedy, says, if you pay me, I'll put some of that money back in the hands of the victims. All kinds of details about the orders. You can see now at the bottom, we got the same thing. Please call the phone number, ask for Ken. Due to high demand, please call back if busy. So this is just further irritating the community, saying keep trying to make sure that Ken gets your phone calls. The last one I'll show is another example. This is the same kind of deal. You can see at this time now, they've changed the price to 75 cents donation. They've got now, instead of just t-shirts, they've got bumper stickers and keychains. Again, someone went to a lot of detail to put all this together. This is not your standard garden variety prank. Someone tried to really make this look like it was a credible statement. Here's the Oklahoma, the Daily Oklahoman story that says, hey, there's this guy, Ken, and everyone's calling him, but this was all a big prank on him. So maybe you should rethink that. And so this was, I think, the beginning of things improving when when the newspaper was able to start educating the Oklahoma City community about the situation. Okay, so those are some of the facts that got us to this way. It's this terrible bombing, and then this serial online attack against Zeran, using these offensive statements too soon, and providing enough credibility to make it look like they're legitimate. So who should Ken sue? This is what I ask my class when I teach this case. Who are the defendants in this case? Well, let's start with the obvious. Whoever is the person who posted these items is the person who should be the number one defendant. As we know, they were pseudonymous. They used the names Ken ZZ033 and Ken Z033. And so we don't actually know who they are. We simply have these aliases. That's all we know about them. And so this person is never found because of the pseudonym plus the server log wipes, so that AOL couldn't provide any further detail about where the postings came from, made it impossible to find this person. So I have asked Ken, he has been deposed, asking this question, who did it to you? And his answer consistently throughout history has been that he was an innocent victim selected at random, that somebody literally just cracked up in the phone book, put their finger on his name, and decided to attack him in this serial way. The reason why Zeran believes this is because this is what he was told by the FBI when they investigated, that the FBI worked under a hypothesis. This was just a random attack. Someone just picked him. I will tell you, that's not an Occam's razor type answer. That does not sound credible to me. And especially going back and looking at those posts and seeing how much detail and care was crafted into not only making them look credible, but making sure that Ken would be attacked. I just find it hard to believe that someone who doesn't know Ken is going to randomly pick his name out of the phone book and subject him to that abuse. It is possible. That's not the most likely consequence. So my contribution to the book, which I've also posted separately, was I went through the deposition transcript of AOL's lawyers deposing Ken Zeran. It was about 800 pages of deposition transcript, looking for clues about who might have done it. And here's what I came up with. Some of the people I think are likely to have done it are, at the time, Ken had 2 different girlfriends, which, as you know, is a combustible situation if one of the girlfriends is upset about his relationship with the other. But the more likely scenario, based on reading the deposition transcript, is that maybe one of the significant others of the girlfriends was upset at Ken, basically through jealousy, and so viewed Ken as someone to target because of his relationship with their girlfriend. Another theory of possibilities is that when Ken was launching his business, this publication of these rental properties, he was moving into some other people's turf. And so another possibility is that a competitor decided to take him out, to subject him to this abuse as a way of suppressing his competitive involvement. There was also a third possibility, which is he had been involved in some litigation not that long before this attack. And so it's possible that the litigation opponents decided that they wanted to do some extrajudicial resolutions to their dispute. Okay, so the people who we think are the most likely defendants, the person who posted, never found. They've escaped justice. They've escaped accountability to this day. And so I call that one of the great whodunits, mysteries of internet law, if we could ever answer the question of who did this. Okay, what about defendants, the people who phone called him? Now, some of those people probably were just innocent, mistaken people. They overread the postings, but that's the worst they did. But the people who are sending him death threats, who are calling him up and saying, I'm going to kill you, these people are engaging in some really pernicious antisocial behavior. These people would also be potentially good defendants for creating the reason why Ken no longer feels safe. It wasn't just the volume of the phone calls, but the venom that was attached to it. That's not okay. As far as I know, none of these people were ever prosecuted or otherwise sued. These people also avoid all accountability and all justice. A third category of defendants is KRXO, the one that on May 1st said, hey, call this joker and tell him how we feel about him mocking our tragedy. And I'm going to talk about that litigation in a moment. And then finally, an obvious defendant is AOL. They're the ones that had these messages posted. They were the ones that in theory could have prevented this harm. And that becomes the subject of the book in its main. So let me talk first about the KRXO litigation. So Ken did sue KRXO, the radio station. It was owned by a parent company called Diamond. And he sued them in 1996. And he sued them for defamation, false light, and intentional infliction of emotional distress. But really, the defamation is the primary claim here. And in 1997, the district court rules on the case and grants summary judgment to KRXO. Says KRXO is not liable for any of the claims. Ken appeals that. It goes to the 10th Circuit. And in 2000, the 10th Circuit affirms the dismissal, says that Ken has no claim against the radio station. And with respect to defamation claim, this is the key quote, the plaintiff has not shown that any person thinks less of him, Kenneth Zeran, because of the broadcast. All that the postings had listed was the name Ken and a phone number. And the court said in Oklahoma, the name plus the phone number is enough for people to think of the name Ken Zeran. And so it could be any random Ken who's not in the local area. And because it could be any local Ken outside of Oklahoma City, that doesn't mean that there's harm attached to Ken Zeran. I encourage you to think about that really, not only from a defamation standpoint, what does it mean to have an identity that's can be defamed, but also think about it from a privacy standpoint. Today, knowing the first name and a phone number, we would treat as knowing the identity of that person. And there's a whole bunch of privacy laws that say that. But at the time, it was actually quite hard. If you know Oklahoma City, it would have been very difficult to get a phone book and be able to do a reverse search to figure out who Ken was associated with a particular number. That actually really was a hard thing to do. And so the court basically says, we don't know who Ken is, and as a result, he can't be defamed. So the lawsuit against the radio station ends up with nothing. Though they poured the gasoline on that fire, no accountability for them. Now let's talk about the lawsuit against AOL. In order to understand this lawsuit, we have to start with the foundational law of Section 230, which I mentioned earlier. It basically says websites aren't liable for third-party content. Now, this was passed in February of 1996 as part of the Communications Decency Act, which itself was part of the Telecommunications Act of 1996, a major reform of our entire telecommunications industry back in 1996. And as part of that, there was the Communications Decency Act, which was really the Congress's first attempt to regulate internet content. What it said was basically, if you have internet pornography, you need to put it behind paywalls to keep it from the children. And that law was struck down in litigation that came out in 1997, Reno versus ACLU. The court said that part of the law was unconstitutional. Now, part of the Communications Decency Act was Section 230. And the reason why Section 230 was a part of the Communications Decency Act, though it had nothing to do with internet pornography, is because basically they were viewed as rival alternatives. The Senate passed the Communications Decency Act, the House passed what was Section 230, and in a conference between the House and Senate to reconcile their different versions of the Telecommunications Act of 1996, they basically put the two together. They said, well, we're not going to pick one or the other. Let's just combine the two. So you have these two very different radical policy approaches. The Communications Decency Act trying to shut down a lot of conversations online. The Section 230 basically saying websites aren't liable for third-party content, enabling lots of conversations, are housed under the same bill that's all part of this much bigger bill that no one really paid attention to. And I did a recent post on Section 230's 25th anniversary, which was February 8th, 2021. And then I talked about how when the Section 230 was passed, there was no parties taking place in Silicon Valley. There was no one saying, yeah, we just got the law that's going to enable us to make trillions of dollars. It was really a quiet corner of this very complex bill that was passed by Congress. And I don't think it wasn't really until the Zeran case came out in 1997 that I think we finally appreciated just how significant Congress's law really was. Okay, so why did Congress pass Section 230? I'm quoting from the legislative history, and it says here, one of the specific purposes of this section is to overrule the Stratton-Oakmont versus Prodigy case and other similar decisions that treated providers or users as publishers or speakers of content that is not their own because they have restricted access to objectionable material. So in 1995, there was a case called Stratton-Oakmont versus Prodigy. Stratton-Oakmont was the investment bank. There was an issue in the Wolf of Wall Street movie. If you saw that one, it got a lot of attention. And if you watch that movie, you'll see Stratton-Oakmont was actually a pretty sketchy operations as far as we can tell. But someone on Prodigy went to one of their proprietary message boards. Prodigy was just like AOL. It was like a one-stop shopping of internet services. And on their message board, someone posted a message critical of Stratton-Oakmont. And the investment bank sued Prodigy saying, you published this user post and you should have cleaned it up. And how do we know you should have cleaned it up? Because you were cleaning up other stuff on the site. And because you advertised yourself as a family-friendly service. And so you said, because we're a family-friendly service, we should be keeping it so that it's safe for the children. And the court in the Stratton-Oakmont case said, well, if that's the case, why didn't you clean this one up? To which Prodigy said, and Congress said, wait a minute, hold on a sec. What you're saying is that Prodigy tries and fails to create an environment that's family friendly. They're going to be worse off than if they never tried at all. That's not a good deal. So Section 230 says we want internet services to be engaging in the kind of content moderation that's going to create family safe environments. We want to give them that legal protection, and we don't want them liable for whatever mistakes they made. So Section 230C1, and there are other parts of 230 we want to talk about today, says no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. My co-author, Jeff Kosseff, has written a book called The 26 Words That Created the Internet. These are the 26 words right here. Now, I want you to try to take all the context I've already given you off the table for a moment and just read these words. And you're probably going to say, what does this mean in English? Who is a provider or user of an interactive computer system? What does that even mean? We don't talk that way today. And I will tell you, we didn't really talk that way in 1995 or 1996. And what does it mean to say someone shall not be treated as the publisher or speaker? What does that mean? Why are we talking in those terms? Why are we not talking about specific causes of action? Why don't we just say defamation? They can't be sued for defamation, or they're not liable for certain things. But that's not the grammar that was used here. And who is this? What is this thing called information provided by another information content provider? Just notice how stupid the term is. Information content provider? What does that even mean? Go back to Professor Sandin's talk. Is there some possibility for there to be information non-content or non-information content? This is just weird drafting. And so these 26 words were designed to fix the problem that was created by the Stratton Oakmont case. This idea that if you tried and failed, you would be worse off than if you never tried at all. But the way they wrote it doesn't really say that. You have to really kind of think carefully. What do these words mean? And that leads us to the Zeran versus AOL case, which answers this question. Remember, the law was passed February 1996. Zeran was attacked in 1995. And actually, another part of the case doesn't get a lot of attention today is that the court said that the law would be applied to these retroactive activities because Zeran filed his case after the law was already in effect. He filed in April of 1996. So Section 230 passed February 1996 applied to his case, even though the facts took place beforehand. Okay, so in April 1996, Zeran sues AOL, and he sues them for negligence. So he sues them basically saying, you should have kept the record so that I can figure out who done it. And he doesn't directly sue them for defamation, even though the messages that we saw all claimed that they were coming from Ken, but clearly they were not. And he sues in Western District of Oklahoma. Now, remember, Ken is based in Seattle, and AOL was based in Virginia. So Western District of Oklahoma was, I think, clearly designed to be a venue that would get local sympathy, right? Everyone here is going to be pretty sympathetic to Zeran because of the offensiveness of the messages. In October 1996, AOL successfully transfers the case over to the Eastern District of Virginia, its home court. And I don't know if it's still called this, but at the time, the Eastern District of Virginia was called the Rocket Docket because it was known for cranking out cases quickly. And in March of 1997, so just 6 months after the case is transferred, the district court grants AOL's judgment on the pleadings. So for those who don't remember from civil procedure, judgment on the pleadings is that Zeran filed his complaint. AOL filed an answer. There was some limited discovery done, like the deposition that I read to do that gave that transcript. But then AOL said, we don't need to rely on this discovery. Based on the combination of the complaint and answer, we win. And so the court agreed and said, you get judgment on the pleadings. Based on the complaint, based on your answer, there's no way for Zeran to win. So Zeran appeals that to the Fourth Circuit, and again, consistent with this Rocket Docket situation. Notice that in November of 1997, so just 8 months after the district court opinion, we get the opinion from the Fourth Circuit, where the Fourth Circuit affirmed the district court. So notice that from filing April of 1996 to November of 1997, about a year and a half. And the reason why that's important, because there were some other cases that were percolating through the courts that took longer than this case. And those other cases could have reached wildly different outcomes. And we have an essay in the book about that. But because the Fourth Circuit acted so quickly, because the Eastern District of Virginia acted so quickly, we get an opinion. The court says that there's no distinction between a publisher and a distributor of content. And there were concepts in defamation law that distinguish between the court says Section 230 doesn't make that distinction. And so one of the things you can take away from this talk, you probably have heard people online say there's a distinction for Section 230 purposes between publishers and platforms. If you act as a platform, you get Section 230. If you act as a publisher, you don't. And that's just clearly wrong. That's always been wrong. It actually misunderstands the Stratton Oakmont case, which is the reason why Section 230 is on the books. The Congress said we don't want to turn Prodigy into a platform that just simply hosts people's content. We want them to be exercising their editorial discretion to make it family friendly. We want them to function like a publisher. And so this is the case, though, that said there is no publisher platform distinction. Section 230 applies equally, whether someone's characterized as a distributor content or a publisher content, they both get Section 230 protection. The case also says there's no notice-based liability of Section 230. Zeran said, I told AOL they should have known that there's this problem taking place. They should have gone and intervened. The court said that doesn't matter, Section 230. There's nothing in those 26 words that turns on notice that the service might have. If the service is told there's a problem and doesn't do anything, if they don't deal with it quickly enough or they never do anything at all, they still get Section 230. Instead, the court says, and this is, I think, the most important passage from the opinion, quote, 230 forbids the imposition of publisher liability on a service provider for the exercise of its editorial and self-regulatory functions, such as deciding whether to publish, withdraw, postpone, or alter content. And I think the way to read this is really, if it's third-party content, if it's not the service's own content, Section 230 says they're not liable for it. Now, there's some statutory exclusions. There are some common law case exclusions. Happy to talk about this in the Q&A. But what this opinion does is it says, if someone is exercising the publisher-like functions, if they are editing, if they're publishing, if they're making decisions to pull back or modify or postpone or delay content, it doesn't matter. Section 230 covers all of those functions. And so it doesn't really matter if you say, the service did this or the service didn't do this. It doesn't matter. Whatever they did or didn't do, Section 230 still applies. Finally, I will add that September 1998, this case went to the Supreme Court. The Supreme Court denied certiorari. The Supreme Court has not taken a Section 230 case in the 25 plus years that the law has been on the books, although Justice Thomas has signaled that he is desperate for the court to do so. So some of the legacies of the case, some of the reasons why this case remains such a great classic internet law story even today. So the number one thing I'm sure you took away from this is that Zeran walks away empty-handed. Someone perpetrated this horrible attack on him that disrupted his life for weeks, and nobody ends up being liable. AOL's not liable because of Section 230. The radio station's not liable because they never, quote, defamed him. And the poster's never found. The people who made the phone calls never prosecuted. Nobody ends up being accountable for this particular harm. And that raises all the questions we have today. Who is going to make sure that we don't allow these kinds of attacks to occur? That we don't want victims to feel like they're powerless in a system like this. And the Zeran case is a cautionary tale about that. We knew that was the risk 25 years ago. And some of the policy questions that are open today, of which there are many, questions like, should we allow anonymous or pseudonymous speech? This attack would not have likely been conducted on Zeran if there had been requirements to attribute the content or if people had to use their real names. But we also know that if we require an attribution or people to use their real names, we get a very different internet. There's a lot of things that we enjoy today that would simply go away. And one obvious example, things like whistleblower content or things like it simply don't exist in an environment where the person can end up being accountable for what they say. And so we have to strike this interesting balancing act, a question that's still going on today. And Jeff's next book will actually address this issue. So he's got more to say on that topic. So what about, shouldn't the internet services keep better records? Part of the problem here is that AOL wiped its server logs. If they had the server logs, Zeran might have been able to get a better degree of justice. On the other hand, keeping server logs is a major privacy violation. There's been increasing pushes to get internet services to get rid of more information and to get rid of it faster or to never collect in the first place. So this same question that was at issue in this case is still current today. One of the obvious questions here is, why were people treating these postings as credible? They could have easily identified, this is probably a prank. This is not something where I'm actually going to call and choose somebody out because I know that someone's pulling a prank here. And the good news is I think some of us have gotten smarter over the years and recognize this risk. And unfortunately, we still see pranks like this work even today, where people are posting anonymous or pseudonymous posts And people are treating them as credible when we all really ought to know better. So what are we going to do about that as a society? How are we going to educate people to keep a prank like this from working? And then what do we want AOL to do? What should AOL have done differently when it came to moderating the content that was posted attacking Zeran? And the easy answer is, well, they should get rid of it. And maybe that is the right answer. But there's a lot of circumstances where that would be the wrong answer. And in order for them to do that, they might have to build a more industrial grade content moderation system that costs them a lot more money. Maybe it means that they won't be able to make a profit from the message board system. Maybe it means they won't be able to offer that in the first instance. So we don't get anything for free here. If we want AOL to do more here, it's possible AOL won't do anything at all. They'll simply exit the industry. And so we have this balancing act that we're constantly trying to establish. What do we want AOL to do here? It's a question I ask my students when I teach this class. And the answer is, well, I wish this didn't happen, but I'm not sure that I would mandate that AOL do anything differently either. Certainly, we have to ask the question, what should AOL have done in a situation where there's a serial attack? Is there some way for them to better manage serial attacks? This is still ongoing today. There was a recent Section 230 case from a couple of years ago, the Herrick versus Gardner case. A serial attack. We still see those even today. They're not new. We see that they were conducted back in 1995, and yet we still don't have a good answer about how to avoid them. And then what do we do about preventing cyber mobbing? So I view this as a cyber mobbing type situation where Zeran was attacked by a distributed audience of people throughout the globe, all independently choosing to go and harass him based on this instigation. And what can we do to prevent that? Cyber mobbing remains a problem today. We know that people are literally attacked by people who don't know them on the basis of really small situations. Sometimes we'll call that cancel culture, but sometimes it's just a pernicious attack that's deliberately instigated. We still see that today, and we don't know what to do about it. So one of the reasons why this case is so classic is that it raises all these issues that are very current today in 2021, and they show how difficult they've been for the last 25 years. I'm sorry to conclude with very little to say about the book, although I've talked about some of it, but let me just give you a quick overview of the book, and then we'll turn over to the Q&A. So here's what the book does. So the book first includes many of the key filings in the Zeran versus AOL case. You can see how the case proceeded from complaint through certiorari petition and defense to the Supreme Court. And so it's a case study of how this litigation operated, both as in the 1990s, how the debate was framed then, but also just as a case study of litigation, showing how the case goes from stage A to stage Z. We also include I'm sorry, that's a typo. My apologies. I also include the opinions from Zeran versus Diamond. So you can actually read the opinions involving the KRXO case as well. And then the other major component of the book is we have 24 essays that were written back in 2017 to celebrate the 20th anniversary of the case. And these are written by basically an all-star luminary cast of internet law experts. And so here's some of the names. If you look at these names, I'm sure you're going to recognize some of them. If you know anything about internet law, these are people basically that Jeff and I went to and we said, we want to hear what you have to say about this case. What has this case meant to you? And some of the contributions are historical in nature. So like mine was reading through the deposition transcript and trying to answer the whodunit question. Or Jeff's contribution was about a profile of the author of the Fourth Circuit case, Judge Wilkinson. He explains why Judge Wilkinson might have written such a exceptionalist and broad opinion. And there's submissions from the actual litigation counsel about what they were doing in this case, why they did what they did. We also have one that summarizes the AOL versus, Zeran versus Diamond litigation. So we have some great historical pieces. And then the rest of them are basically thought pieces about what we learned from this case. Some people saying we learned how much we need Section 230. And some people saying we learned that Section 230 enables great harm to people. And so we have a whole mix of opinions and perspectives about the legacy of Zeran and Section 230 as a snapshot of how we were thinking about them 20 years afterwards. So I'm really excited to share this book because this case is so important to the internet law community, because it's filled with so many gems of perspectives from smart people, as well as these materials that help you understand what is a pivotal case. Thank you for giving me the opportunity to talk in this book. Sorry I talked so long. Let's see what we can do in terms of conversation.
Terrific. Thank you, Professor Goldman. Raise your hand if you have a question. I'll kick things off. Actually, why don't we go Professor Sandine, who I know has a class to teach. So go ahead.
Yeah, thank you, Eric. It brought back memories of studying that case when I got my LLM at Berkeley in 2001, 2002. And also I wrote my LLM thesis was on the constitutional right of anonymity. So I'm going to have to go back and read that article to see what I said about this case. But I have a question. I was looking at the actual statute called the Communications Decency Act recently. And I know Professor Kosseff has written the book, The 26 Words, but I was, obviously the section has more work than 26. But I was also struck by the fact that it has a lot of non-codified language in the CDA, including a lot of the history, kind of a little history of why the Congress was doing this, that explains exactly a lot of what you just said. And I'm wondering why that's not more, more a part of the public discourse on this issue.
I don't have a single answer for you about that. I will tell you that, at least with respect to Section 230, the Zeran case was written in such an emphatic, confident style that I feel like many people took that as the answer. There have been people who since then who've mined the materials from the passage to try and find different interpretations of history. And I'll give you an example. There was a dissent in a Second Circuit case called Force versus Facebook, where a judge wrote a really stinging opinion of Section 230 generally, and tried to tell a different story about the history. So I think there are attempts to do so, but the combination of the Zeran case being so emphatic and clear with then the nature of common law generally, that once you have this beachhead precedent, it becomes an anchor for future precedents, I think really steered the entire conversation in a very specific way that's been hard for us to consider a different norm. I don't think we're likely to see further mining of that history. I think the more likely scenario is that Congress will amend Section 230, and that will become the new baseline. So it's one of those mysteries of history, I guess. Why didn't that cast a longer shadow?
Johan? You're still on mute.
I'm sorry. Hi, Professor Goldman, and thanks for the presentation. And I had a question about Stratton-Oakmont. So what was the theory in Stratton-Oakmont, and why was what got Prodigy into trouble? Was it the fact that they represented that they're going to police the website? Because the more natural solution for them would have been, to me, it seems, just to say, look, we're just hosting other people's content. We're not policing here anything. But was that the problem, that they said, hey, we're going to police this and just make it safe for children or whatever? Was that the problem there?
Yeah, it's an interesting question. So just to clarify, so let's start with the basic premise that defamation liability is strict liability. If you make a defamatory utterance, you publish it to another person, and it causes harm or injures someone's reputation, it doesn't matter if you knew or didn't know about the veracity. It doesn't matter if, in Prodigy's case, if they knew that this particular statement might be allegedly defamatory, didn't really matter. Because it's strict liability. Now, there are some exceptions to that. The First Amendment requires that actual malice be imposed before there's a liability for statements about public figures on matters of public concern. So there might be some standard adjustments, but the starting premise is, if you publish content and if it injures someone's reputation, then you're liable for that. So that's the basic headwinds that Prodigy was running into. The plaintiff says, you published it, it defamed me, you're liable. Now, the defense is, but we didn't know because we simply provide these hosting tools, and we should now have the basis on which to avoid them. And the court said, I don't believe you and say you didn't know, because you were doing all these other things to your database. You were doing content moderation elsewhere, and you were marketing yourself as actually trying to affirmatively manage your content database. And that's what got them over the hump, where they come in and say, we're just hosting message boards. The court said, no, you either knew or should have known about this content because of the fact that you were doing these other things. And that's what really caught Congress's attention. The idea, we want you to do content moderation. Content moderation is socially beneficial. It helps keep kids safe. And this court was saying was weaponizing those efforts against Prodigy. So the short answer is they tried the argument you just wanted them to make, and the court didn't buy it. And that's what required Congress to intervene.
Okay, I have a question, and if any others, please do raise your hand on Zoom. I'm fascinated by the whodunit question, and thanks for sharing some new information that I wasn't aware of. One question that relates to that, why was AOL allowed to ask questions in the deposition about the girlfriends and the competitors? What was the angle that they were trying to establish there? And then sort of secondly, did Zeran not change his phone number? And was he ever sort of a suspect too, that this was staged, et cetera, or whatever?
So with respect to your first question, Zeran's lawyers strenuously objected to the questions that you mentioned, for the very reason you mentioned. Who cares who done it? That wasn't relevant to theory of the case. Part of the argument is that AOL's lawyers argued that it might be relevant to damages. And I don't know if I fully buy that, but they thought there might be information they could elicit from identifying the perpetrator that would then potentially modify damages. But yes, if you read the transcript, you'll see, and I'm sorry, the transcript's not publicly available. I got it through some proprietary sources, and I've never felt comfortable posting it publicly. So unfortunately, you can't. But if you were to read it, you would see these objections every single time. In fact, I remember one line basically where Zeran's lawyer's like, there you go again. You're pursuing these questions about the whodunit. Why are you wasting our time? So yeah, there was some of the typical deposition squabbles that you might imagine between lawyers when they're dealing with a disagreement about whether or not a line of questioning was relevant. In terms of the question, did Zeran do this to himself? So I will be candid. I have heard that theory. I have seen no evidence to support it. I can't wrap my head around why he would do that. It really doesn't make any sense. So I don't see it as an Occam's razor explanation. I see that as something that is a very esoteric approach. But you know, the reality is today we have no idea who did it. We can only speculate.
Okay, any other questions? I have another question if no one else has a question related more to the Section 230, and you've already referenced that we may see Congress amend Section 230. I'm just curious to get your thoughts about why Facebook is so, gung-ho about changing it. I've never heard Facebook buy an ad before this. And, I've heard their ad on, I think it was Spotify. I've seen their ad on the top of Washington Post. They're pouring money, a lot of money into this. I don't know if it's all public relations, but they're pouring a lot of money into seeing Section 230 amended. And I guess I'm just curious your thoughts on why they're doing that. Why are they doing something that seems, even if they're for reform, it does seem like they're taking out these advertisements in a way that they've never done before.
It is a major frustration of mine, and I will tell you, I think that there are many other industry participants who are not pleased by Facebook's move. But as you pointed out, Facebook is not normally advertising to generate new customers or to stimulate demand for its services, but it is advertising to tear down Section 230. And so it really just shows where their priorities are. They don't even think they need to worry about getting new customers. That's not something they need to pour money into. But they do think that it's worth the investment to pour money into the regulatory game, which should start to raise your hackles about why would that be a good investment of money? What is it that they think they're going to be able to accomplish? And the short answer is the most prevailing explanation for Facebook's public stances about Section 230, where they favor reform of Section 230 and they're willing to put money to support that, their support for it, is that they're viewing it as a way of basically consolidating the industry. That if they can get Section 230 reform, they have enough money to be able to comply with it. They think their competitors would not have enough money. And this is their way of closing the barn door to keep anyone else from entering. It would be offensive to us, I think, in our sensibilities to think that an industry giant would engage in such kind of blatant anti-competitive moves. And yet that is the most likely explanation. There's not a good explanation otherwise. And I will tell you that there's also a just extraordinary degree of hubris underlying Facebook's move. They think they can get the reform that helps them and will hurt their competition. And yet, if you look at the macro dynamics, Congress wants to help their competition and wants to hurt Facebook. And so there's an extraordinary degree of confidence that Facebook thinks it can steer this rocket ship called Congress to achieve the regulatory outcome that they want and will view as a win without any risk of getting something that ends up actually hurting them and not their competition, or worse, hurting everybody. And most of us in the industry don't believe that Facebook is going to be able to navigate that needle threading. And so it's very upsetting to me to see Facebook pouring money into a move that is weaponized against not only Facebook, but the entire industry, saying, well, look, Facebook thinks Section 230 is modifiable. That's good enough for us. Then, one of the leading giants thinks it's good enough. Let's go do it. But then they're going to do it in a way that hurts everybody. And so Facebook's move has extreme risk of backfiring, not only for Facebook, but for all of us. And that's one of the reasons that makes me pretty upset.
Okay, I just wanted to point out, I shared the link to the book. It's in the chat. For those of you who have not seen it yet, you can click on the chat. It looks like we have no remaining questions. So why don't you join me in thanking Professor Goldman for his fascinating discussion about his book on Zeran versus AOL. Please do download it and read it. There's a lot to digest. And one last announcement is we have one final book talk for the semester. It will be next Friday with Professors Kaboli and Ginsberg talking about their book on trademark law. So you can feel free to email me if you are interested in getting the registration for that event. So with that, have a great day, everyone. It was wonderful for you to join us, and we hope to see you back next Friday.
Thank you, Professor Lee, for doing this. Again, what a great honor it is to be a part of it.